Good morning, everybody. Glad to have you here. Welcome to the second installment of GovLaw's Friday Forum. I am Spencer Brown, Associate at GovLaw. I'm joined, as always, by my fellow associate, Zach Currie. Today, we're going to be discussing Into the Breach, which is our sort of introduction to preparing for trial. A lot of what you'll hear today is part of GovLaw's classic primer, Prosecute This, which if you think there's something that you could get more information on that you hear today, or you want to do a more in-depth and active course on prosecutions, I strongly encourage you to take Prosecute This, which will be hopefully on offer here in the next 8 months. We're not exactly sure on the timing, but we will follow up with everyone in attendance and get them an invite when that does happen. So today, we're going to be talking about what you need to do, or key steps for preparing for a prosecution in court, sort of a trial, and just some pointers on how to avoid the common pitfalls and how to make the best case. First, a caveat: this is information for prosecutions for MTIs only. If you're considering doing an LFI, that is really something that you're going to need a lawyer to do. There's the possibility that those will get bounced right away for lack of authority to prosecute those sorts of information. So this is all about your tickets, your municipal ticket information prosecutions under the Offence Act. And we're going to start off with the core of every prosecution, which is the elements of the offense. And this is something that you can start to take into consideration from the moment you issue the ticket. Even if you haven't received a dispute yet, you should have in your mind these elements of the offense. And I think, Zach, do you want to tell everybody what these are?
Yeah, sure. But before we get started, I just wanted to say that this should be like a free-flowing conversation. So if you have any questions, please put them in the chat and we'll read them out as we go and answer them as we go. Any questions you have at all. So yeah, starting with the elements of the offense, this is something that Troy actually taught me when I first started. He said, this is critical. You always got to do an elements of the offense. And it essentially lays out a schedule. You're gonna, however you want to do it on Word, etc. You're gonna have a few columns. On one column, you're gonna have the elements of the offense. Another column, you're going to have your facts. Another column, you're going to have the documents supporting those facts. And then maybe another column for notes to yourself on things to follow up on. So the elements of the offense column is essentially breaking down your bylaw contravention into the components you have to prove. So if you've got a bylaw that says no person shall permit more than 2 commercial vehicles to be parked in an A1 agricultural zone, then you're going to break that down into no person. So you've got to identify the party, which is sometimes more complicated than it seems. It depends. Maybe corporation owns the property, so you got to have the corporation, company summary, and then you've got to find out who the director is, etc. So you got to make sure you're always paying attention to who are you actually prosecuting and how many parties can be prosecuted. Maybe there's a few people on title and you can prosecute all of them. The second part would be allow or permit. That's its own type of element. You're going to have to prove that that the party is allowing this thing to happen on the property. No more than 2 commercial vehicles. So do you have the right number of vehicles? And then commercial vehicles, maybe it has its own definition in the bylaw, probably does. And then that's going to be almost a separate sub-elements of the offense. We have to break down the different components of the commercial vehicle definition and make sure you have all those things, that the things you're saying are on the property are actually commercial vehicles. And so you can see that this sort of lays out what you have to prove. And what's so important about it is that sometimes, almost actually all the time, when we start a case and you're collecting, you get a complaint, you go to collect evidence, you early on develop a theory of the case, which can quickly bias you and create blind spots for you. And going through the elements of the offense really allows you to think through your case clearly and make sure that you're really proving everything, because you've got to prove every element to get a conviction. You can't just prove the majority of the elements or have some sort of general idea that bylaw contraventions are occurring on the property. It becomes very technical. This is part of the legal process.
Yeah, that's it's the way Zach has put it is perfect. I think even lawyers get kind of lost in their sense of the case themselves, and they forget that because they know, or they're so sure that the offense has taken place, that there are elements that still need to be proven in court, including identity, location, date. These things can seem almost patently obvious to the individual, but there has to be evidence that establishes that in court. And I would be remiss at this point if I didn't mention that we have our handsome new associate, Sam Maloney, behind the camera here, and he's going to moderate the chat. So if you do have any questions, put them forward, and he'll be delivering it in his soothing baritone.
Speaking of that, I do have a question here. Zach Keating's asking to clarify something you guys said at the start, that they don't have the authority to prosecute LFIs and they need a lawyer.
Yes, that's correct. There's a directive and a practice point for lawyers to prosecute municipal offenses, but there is no such directive for other municipal staff or local government staff. So although it's not a given, it is a possibility that please, yeah.
Yeah, I would agree with Spencer. I would say that there's probably room within the practice directives and that are interpreting section, I think it's 260 of the community charter, that municipalities with their own staff could prosecute a long form information, but that's not a given. So you don't want to go to court and then have everything blown to pieces just because you decided to do something that appears to be novel, right? And we've had opponents on the other side surprisingly challenge our authority to prosecute cases, and the judges really took a concern about that. So it's something that I wouldn't risk, whereas the authority to prosecute MTIs is very clear that a bylaw officer can do that.
And in a practical sense, an LFI comes with additional considerations, legal considerations that ought to be handled by a lawyer. The sort of degree of difficulty goes up substantially between the two. It would be my recommendation, regardless, that a lawyer handle an LFI. Yeah. There are even provisions under the Offence Act that in a ticket prosecution, the judge can be lenient around evidentiary issues and things like that. So it's much more amenable to lay litigants than the LFI process, which is essentially indistinct from the criminal trial process with all of its technical and practical requirements.
I think, just for an example, on an MTI, you can give the bylaw provision that that the person is contravening, but it's different when you and go ahead and prosecute on that ticket. You don't need much detail, actually. But when it gets to an LFI, because you have to structure the counts in a proper way, that's where more technical difficulties come up. Even though it seems as if a count is the same as an MTI, is actually different, and it matters how you word that count. It can be fatal to your case if you don't word it the right way.
Mm-hmm. Yeah. I want to cycle back to something that Zach mentioned, which is the sort of bias that comes with the prosecution and not recognizing the evidence. And I want to turn to sort of the second point that we're talking about, which are largely impermissible types of evidence, which in the bulletin, you'll see that there's two that we've named, which is speculation and hearsay. And these are important things to consider when you're cultivating your evidence, when you're curating the things you're going to bring forward to the trial. Because hearsay, and even hearsay is a kind of complicated concept. Even the Supreme Court of Canada differs on its exact limits. But basically, it's an out-of-court statement that you're trying to use for the purpose of establishing the fact in the statement. So a classic example would be somebody who's not present in court said to you, I saw Jim let his dog run without a lead. And then you come into court and you try to present that statement to the judge, and they're not going to accept it because they can't scrutinize it for truth. They can't examine that person, the statement maker, to make sure that they weren't lying, that they don't have a grudge against the dog walker or whatever. So it's important that you have only direct evidence. You have witnesses who saw an offense take place, or who are the complainants, etc. You want to have their direct testimony and not a second or third hand statement.
Yep, 100%. And this can get highly technical at times, but I think that Spencer's laid out the general idea. And if you stick to that, I think on most MTIs, which should be simple, a simple process, you'll be safe. Just make sure you have the witness with the most direct evidence, giving that evidence in court. As far as I think on speculation, which is a bit of a different issue, it's related to hearsay, because often the speculation can be broken down into essentially hearsay. But for example, if you've got an example of this might be that you've got a complainant that says that somebody's operating a commercial business on their property or something like that, and they say, I know that they're getting paid to do this, that people are paying them to repair cars on their property. Often this is not, they don't have direct evidence of that. In fact, it's just an inference, right? The idea is like, well, you would only do this if someone was paying you to do that. But that's not enough for the court. You've got to have direct evidence. So you don't want your case to rely on these kinds of things where the judge can make inferences from the evidence, but sometimes that inference is too tenuous, and you need to make sure that you're not relying too much on just inferences from the evidence, and rather stick to kind of the cold hard facts of what can be directly observed or proven through documents.
And I think as many of you know, like in modern communities, there's sometimes disputes as to between neighbors or between residential streets as to what the proper character of the neighborhood is. So sometimes you do get people who are conscripting the bylaw process to affect a dispute. And that can lead to a lot of speculative complaints, like, I don't like this person, so I know whatever they're doing on their property must be wrong.
Yeah.
They annoy me, so therefore it's a noise violation.
Yeah.
So these sorts of things. I think this is a good point to discuss the other side, because we've talked about getting your evidence a little bit, but you also have an obligation in a prosecution to the accused or to the offender. You have to disclose not only the key evidence that you're going to be using to prosecute the offense, but also anything that might be relevant to the matter at hand, which can include, unfortunately, some things that might take away from your own case. So you want to be careful when you are, in particular, making notes during your investigation, when you're gathering evidence, that you don't do so in a way that would suggest that you are making a character judgment, or you have your own bias against the offender. Anything that they deserve or that they're entitled to receive at law has to be given to them, or the case can be bounced. So you want to make sure that all of the evidence, and within all of the evidence, there's no indication of inappropriateness on the part of the government.
And the relevance is very broad, if that wasn't clear from what Spencer said. I mean, it's essentially boils down to, is there anything that the defendant can reasonably rely on to put up any kind of defense? So it can just be evidence that itself isn't directly germane to disproving the case, but could lead to further evidence that would disprove the case. So and most of the times you're disclosing more rather than less, subject to, I think, some important rules. I think the most important for the purposes of just optics and administering the law in a way that the public is happy about is informer privilege, right? So you want to make sure you're not giving out any information like that about informants. And so you have to go through the process of redacting, not just for the purpose of making your case as strong as possible. This is for the purpose of complying with rules that if you don't, there could be serious consequences for.
Yeah, and as many of you I think, are in local government, which is our political creatures, there are policy considerations to be made here as well. You want to make sure that when you're preparing a case, if you have civilian complainants, let's say, who are the backbone of your evidence, you want to be clear with them that if it goes to a prosecution, if it goes to trial, they will be required to give that evidence in court, and they have to be identified within certain parameters of reasonableness to the defendant.
Yeah.
And that can make people very uncomfortable, and not unrightly. I think a lot of people are scared by having to face the people, even if they have a genuine complaint. It can be daunting. So it's good to prepare your complainants for that fact, and it's good to confirm with them that they are in fact comfortable, because then you have to make a political decision, essentially, whether you want to weigh the damage that could be done through subpoenaing a witness sort of against their interest, or maybe having to drop the case, give up the dispute. There's another aspect of MTIs there's another aspect of LFIs that doesn't play into MTIs as much, but it's still something to consider, which is just getting into a dialogue with the defendant and seeing if you can get to some sort of resolution, either a joint submission with the city or the municipality, local government at trial, or some form of arrangement so that it doesn't have to proceed to a full trial. It's always good to spare the local government those kinds of expenses by just seeing if there's any chance of working out an arrangement. You don't have as much leverage as in an MTI, because there isn't the opportunity to impose orders for compliance and heavy fines, but I still think there is still an opportunity for dialogue prior to trial.
Yeah, everything in any case, things can be settled outside of court. I mean, compliance is the main goal, right? So it's unlikely that a local government is going to go ahead just prosecuting just for the sake of it. And so that's where you want to get into looking into the details of doing up, well, I guess on a long form information prosecution, a consent order, but I guess you could have on an MTI, you could file a consent order even on an MTI too, right?
I suppose it's practically available. Yeah.
Yeah.
It'd be interesting because the defendant could, if it was a consent order for certain things, the defendant wouldn't be subject to any sort of orders, but they could still agree to do some things, I suppose.
Yeah, I guess it might come down to more like a compliance order, something more along that lines. Yeah,
I mean, that's a good point, actually. You could customize it. You could have an agreement and then use the opportunity for dialogue to have the defendant sign a compliance agreement. So it wouldn't affect the proceedings under the MTI, but it might get you something that you can paper future compliance measures with, and an agreement, and you could, come to them and look, you signed this thing, yet you're still parking these trucks on the property.
Yeah.
So yeah, it's a
good future evidence.
Yeah, absolutely.
Yeah, you're always thinking long term.
Question here from the chat. Scott Collins asking, can you provide guidance on submissions of evidence where there are several documents that support the prosecution, brackets bylaw, reference, photos, reports, statements, Would you recommend submitting an indexed booklet and referencing each tab as evidence is given, or would the best practice be submission of each document as the story is told?
Well, evidence at trial has to go through two processes. It has to be authenticated and then it has to be entered. So that can kind of constrain how you approach it. You could put it all in one binder. If it's all documentary evidence, you could put it all in one binder and then have it entered as an exhibit for authentication. And then with your subsequent witnesses, talk them through each document in the binder. And once each tab or section of the document or the binder has been authenticated, you enter the entire binder as one exhibit. We're just getting a feed here on the onset facts. I'll just be one moment. Oh, I have just a breaking notice here from our stage manager. I want to apologize at the moment for the early start today. The reason is our beloved legal assistant and receptionist, Julie Garrick, is celebrating 10 years with GovLaw, and we are, as we should, set to celebrate her this afternoon. She's obviously the lodestone of the office. Like, I think an absence of her for more than a couple hours would lead to the whole thing falling in on itself. So we really did want to make sure that we gave her a good parade today. So I do apologize that it's a little bit earlier. I know that coffee hasn't kicked in for many, but it's for a good cause, I assure you. So turning back to those evidentiary issues, that I think is the most effective way, if you have a number of documentary tabs, is to have it in one binder, authenticate each piece individually, even across witnesses. And then once you have finished authenticating each element of the binder, each tab, you then submit that as a single exhibit.
100%. I think that's the best way to do it. It only becomes a problem if the other side starts objecting, right? And then usually that ends up breaking up your flow and your binder, and you've got to get things through one by one. But definitely the most organized way is to put it in a binder, and that one binder will become your exhibit rather than having a whole bunch of multiple exhibits for each piece of evidence.
And it's an interesting point. I mean, assuming if there are bylaws that the officer, a bylaw officer, might be the witness that's speaking to that, and might even be the person that's running the prosecution. So you could stage the order of witnesses in such a way that you are the last person to speak, and you make sure that anything that remains to be authenticated is authenticated. So you can kind of control the document through the process. And then if there are issues like Zach's talking about, where one tab gets impugned, there has to be a voir dire on that, you can deal with it on the fly.
Yeah, I agree.
And that's actually a good segue into the next sort of section we were hoping to talk about, which is the structure of a trial and how it proceeds. And so that's in line with what you're asking about. So do you want to start them off on that?
Yeah, sure. So when you get to trial, the day of, you as the prosecutor, you get to go first. You'll introduce yourself. If the other side is there, they'll which, I mean, I guess there's always a question of whether in a prosecution, whether the trial would ever advance without at least the other side being there. If they have a lawyer, it's one thing. They don't really have to show up, but in most cases, they're going to be there, and I can't imagine the judge going forward without the defendant present. So, although
in an MTI, I think the Offence Act railroads that process.
Oh, okay.
So if they don't appear for their dispute hearing,
right,
it's an automatic
deemed
entry.
Conviction. Anyways. Yeah.
So I mean, that's another benefit of sticking just to the MTIs, is that if you have someone who runs out of rocket fuel by the time the dispute actually happens, then then you get the victory by default.
Yeah, that's good. So it's possible that when you start, you can open with an opening statement. I think on an MTI, given that these matters should be contained to just simple matters, saying more might be worse than saying less. You always run the risk in a legal setting that if you say too much, you might end up causing problems for yourself. And I think that a very general introduction about what you're prosecuting and why is sufficient. I don't think you have to go into any kind of argument or a summary of what's going to be set down. Just say something quickly that you're there to prosecute an MTI, what the MTI is about, and then you call your first witness.
Absolutely, yeah. And so the process with the witnesses is you as the prosecutor, you begin with your witnesses and you call your first witness, and they'll come and they'll do their affirmation or their oath, and you begin with what is known as direct examination. And it's important to remember when you're doing direct examination that you cannot ask leading questions. And the leading question is a question that tends towards an answer. So you have to ask very general questions. Troy has a good sort of basket of routine questions he asks, which are, what brings you to court today, or tell the court about what happened to have you appear today, and that's usually a good way to get the ball rolling.
Yeah, the rule is just keep it to open-ended questions. That's not to say you can't ever ask a yes or no question, but they can't be the majority of what you're asking. So, right. Stick to those open-ended questions. If you find that the person comes to an end at some point in giving their testimony about the case, then you can prod them with another follow-up question if they still haven't given enough, and you can, in a targeted way, ask yes or no questions here and there. But as long as you're staying within the realm of open-ended questions, you're going to be okay.
Yeah, and I think it's a good point to reflect back on the elements of the offense, because when you are interviewing or examining your witness, it's good to have a checklist of something or something like that, a document that has your elements. And if you have brought this witness because of a specific element that they're going to establish, make sure you have something that lets you check off whether that's been accomplished or not, because it's very difficult if you miss an opportunity with a witness to have them give the right evidence to remedy that. I personally have had experience where even when we brought a subsequently very strong supplementary evidence that to fix an issue like that, the judges aren't really happy to see it. They're very keyed into what the witness is saying, and if they miss something, it often is it's game over. There's no second life.
Yeah.
In that kind of scenario. So yeah, have something that lets you know, that cues you to know when they've said what they need to say to meet the offense. And then afterwards, the defendant will get to cross-examine the witness, which it can be a bit tricky, but I mean, for the most part, it's fairly simple, because the defendant can actually ask these types of leading questions that we're talking about. They're allowed to ask pointed, what would be seen in some ways almost like aggressive questions about within reason, of course. But so it's a good idea to prepare your witnesses to prepare them in the understanding that they will be asked at times maybe some pretty pointed questions about why they're there today. In my experience, I've seen everything from, were you paid to be here today, to like, is this because I dug up the backyard or whatever, bringing up old beefs and grievances and things like that.
Yeah, I prepare your witnesses thoroughly and make sure that they're not going to get into any kind of heated debate with the person who's cross-examining them, because it can easily get under your skin. And I've seen it happen where the person cross-examining was able to get under the witness's skin, was otherwise a good witness, and then after he started getting into an argument, which you're not supposed to be doing as a witness, you're not supposed to be an advocate or giving arguments or that kind of thing, and failing to concede certain things, out of taking a positional attitude on the stand, their testimony ended up being undermined, and the judge actually reprimanded them for the way that they gave their testimony. And I feel bad for them because I understand how it happened, but you have to stay cool at all times and just stick to the facts. Just give the facts, and that's it. And don't argue, don't interpret, and don't do anything like that. And I guess it's just not. I mean, this could be you, right? Because you could be getting cross-examined. But like again, I'd say that if you've got witnesses, prepare them for that and make sure that they stay calm at all times.
And for any bylaw officers that are in attendance who may be leading a prosecution or acting as a witness, just a slight caution that the judge will hold you to a bit of a higher standard as a law enforcement officer. They're going to want to see that on cross-examination, you're not. You don't have a personal investment in the issue, and that's something that they're going to be very alive to. So when you're preparing to give evidence or to prosecute and to be subject to cross-examination, make sure that you understand and have kind of locked away at the front of your mind, again, the elements of the offense, so that what you're talking about, what you're giving on evidence on, is just those elements and not any sort of subjective opinions about the conduct of the accused or
their general behavior and personality, right. Nothing like that.
Right. Or and if they're represented, sometimes, I mean, if on an MTI you are against a represented defendant, I would again strongly recommend that you get counsel, because it's lawyers, especially defense lawyers, have years of experience of exploding what are bulletproof cases through sort of psychological techniques and things like that. So it's too much of a minefield to risk a good solid charge going down the tubes because of it's classic sort of from TV to ancient theater. Like it's, the defense lawyer is an able opponent. So you want to be careful with that. There's also, after the witnesses, you do have an opportunity to make submissions. And I mean, Zach was saying before, and I agree, you want to make that as short and sweet as possible, if you even decide that it's necessary. If you review at the end of your case and conclude that the evidence only indicates one thing, and that's the offense was committed, then maybe just sort of thank the justice and let the defense bring their case if they'd like. Oh, actually, that does remind me. The defendant is not obligated to bring evidence. Yep. They don't have to do anything. They can just sit there and stare off into the distance. So a good mindset to be in is that it's you who has the obligation to make sure that everything is present and is before the judge. The defendant doesn't have to do anything. So they don't have to disprove anything, especially they don't have to disprove anything that you haven't sufficiently proved to begin with.
Yeah. So if you haven't, something simple, if for whatever reason your witnesses all get up and then none of them is able to provide testimony on why this person is the owner of the property, for example, and that therefore they should be responsible. They don't even have, there are circumstances in which the investigating officer will have very few, if any, interactions with the person who is essentially avoiding any kind of compliance. And if you don't have that, and you don't have let's say you don't speak to the title of the property, which is like an easy oversight. If you're getting into getting the witnesses to divulge their evidence, and you're trying to get to like the real meat and potatoes of the case, you're thinking, okay, where's the contravention? That's what I need to get out. But something simple like, does the person even own the property? Are they even responsible? If you miss that, and the other side chooses not to present any evidence, your whole case can be lost just on that one point, even though it's clear that there's a contravention occurring at the property, etc. And like Spencer said, the judge is going to hold you to that, and they're not going to say anything. You're going to get to the end, you're going to close your case, and they're going to give you reasons and say, this is why you lost, right? They're not going to give you an opportunity to, oh, wait, I got to recall my witnesses. I do have a title here. Look, I know that they own the property. You don't get any of that. It's prosecutions are in that way, in the way you expect it to be, from like a layperson's perspective or sort of the TV perspective. They are formal in that way. And that kind of thing, which is often seen as a technicality, is taken quite seriously in court.
There's an element of being in court that I think is difficult for even a rational mind to get around, which is that only the person sitting in the witness box is giving evidence that the court will hear. So no matter how eloquent your submissions are, if you haven't through your witnesses adduced the right evidence, then nothing can be done about that. It's only the voice of the witness that matters to the judge. And
I would just say, personally, I find that the judges, and Spencer and I discussed this recently, they pay very close attention to what witnesses are saying. I find that that's where they actually direct most of their attention and effort, is to really getting the facts straight. And you can see the way the judges handle the facts and the questions they'll ask and run through their mind for clarifications. They're really paying attention to those facts. When it comes to, if you make and on an MTI, you shouldn't be making submissions about the law or anything like that. But when it comes to the law, they're going to be, because if you have to make a persuasive point about the law, which you should not in MTI, a judge doesn't necessarily have to take your interpretation, right? So if they're convinced of their own interpretation from the outset, and they ignore yours, there's not much you can do about that, and they're within their rights to do that. But if they miss a really important, key piece of evidence, that's something that they're very worried about, because it's the kind of thing that can leave them open to appeal in a way that's more likely than just giving their own interpretation of the law. Though, of course, wrong interpretations of the law do result in appeals. I think that the facts on a prosecution often matter more than the position on the law, especially on an MTI where it's very simple and there should be no disputes about the law. This is all just to say that if you want to give a closing statement, nobody wants to, the judge is not really going to pay that close attention to your opinion about the law and that sort of thing. They're just going to pay attention to whether you've met the elements of the offense. And so it really comes down to directing your direct examination, and if necessary, cross-examination of opposing witnesses.
Yeah, I think as a junior lawyer, my ego has taken the biggest drumming. Where you stay up all night preparing a submission on the law. You're getting a quote from Shakespeare or whatever. It comes together. It's a beautiful argument. But you think it's gonna there won't be a dry eye in the courthouse, but the judge just doesn't pay any heed. But then you realize when they make their judgment that they listened to, and the case hinged upon a difference in a couple of words from a witness that may have happened 3 to 6 months ago if it's a bifurcated process. So it is evidence is everything. Rises and sets with evidence. And
it can hinge on a date, right? So you have your witness get up, talk about the contravention when it occurred, and they miss saying it happened on November 12th. Right. The judge is going to be very he's going to be very keen to hear that kind of a thing. And if it's missed and you end your case and say, well, I don't know what day that this testimony, the day that they made these observations, so you didn't prove your case. And that's why you always go back to your count. I mean, on long form information, it's your count is going to have your specific date, but on MTI, you're going to have a date, right? A date that you issued the ticket. And don't dismiss those kind of details, because that's central to the case. And it doesn't matter how right you might be about the law. If you can't prove that the contravention occurred on a specific date by a specific person in a specific manner, basically the who, what, when, where, and how, those questions, if you can't satisfy all of them, you're going to lose. And those things are very mundane. They have nothing to do with rhetorical flourishes or anything like that, right?
Mm-hmm. Yeah, exactly. I mean, I'm thinking in a motor vehicle context, which is because there's so many of those sorts of tickets. I've seen a number of cases that fell just on the fact that, which is such an easy thing to overlook, is that the officer didn't have proof of the speed sign. I mean, of course there's a speed sign, that officer probably passes by it 100 times a day.
And that's exactly why they forgot about it.
Yeah, exactly.
Because it's so obvious. And that's why, to tie this back to the beginning, you got to go through your elements of the offense, right? And that sets the schema for everything that you're going to do. And all of your witnesses are going to kind of fit like puzzle pieces within that schema.
I'm thinking now, I would like to say a quick word about strength of different types of evidence. And as I've come to learn, nothing is better for a judge than just the words of a witness. No video evidence, no sound evidence, nothing is as convincing to them as someone telling them what the situation is. Even if the video is someone running an ad hoc business out of their basement suite, it won't matter as much as a civilian complainant who says, yes, I bought a Nintendo 64 from Dwayne Johnson over there at whatever. It's
which is kind of amazing in a way, because we
is.
tend to think like, well, do you have a video of that, right? Like that to us is the strongest evidence. And it's only until you get into a court you realize that, in fact, a video of something is open to interpretation and it can't defend itself.
Right.
A witness, when asked questions about it, about what they saw, can fill in the blanks. A video can't do that. And that's something you don't really see or you don't think about in daily life until you get into a courtroom and you realize that our system, since like the dawn of time, since the Magna Carta, has been driven mostly by eyewitness evidence, and still is to this day.
Like, as a funny example of this, I've had cases where the defendant, just because they're giving viva voce evidence, they've made up what is like a patently absurd explanation for why something has happened, and the judge accepts it because it's the strength of if they're in court and they have the willingness to say it, then it's much stronger than any photographic or video evidence to the contrary.
Yeah.
Sometimes, I mean, not exclusively, but like.
Yeah, sometimes. And that's not to say that documentary evidence doesn't matter. It does. But it's corroborating. You always have to remember it's always corroborating.
Mm-hmm.
And you can't do without it, but you have to remember that it's playing a supporting role to what the people are saying, what your eyewitnesses are saying in court. Yeah.
You and I actually talked before we were doing this about an unfortunate but real part of prosecutions, which is that people do lie. And we'd all like to think that that people will behave even in court with a certain degree of fidelity to the truth, but it doesn't happen. So again, not to flog sort of the same concept, but you want to make sure that you do have this key viva voce evidence, because there's always the chance that the defendant is going to get up and just say something that's patently untrue. Yeah. And if you don't have something solid that contradicts it, the judge will probably at least see that as a reasonable doubt.
And it's also the importance of cross-examination, because that's going to be one of your primary tools to get somebody on a lie. Otherwise, it's surprisingly hard to catch people and a lie on the stand. The judge will generally take, like Spencer was saying, they'll take testimony at face value unless it's clearly incoherent or something like that. But if someone can come up with a plausible story, unless you're able to disprove that with contrary facts, that's going to get in as something that's rebutting your case. And you can't just rely on the fact that the person's taken oath, especially when you think of, the kind of person that you're prosecuting, where you have to get to the point of prosecution as someone that generally has little regard for the law anyways. This seems to be quite common in what we do, just because of the way we escalate compliance. The people at the very end that are being prosecuted are people who they don't necessarily think, they don't have the same respect for for the norms that most people have, right? And so you have to anticipate that kind of behavior in advance, that you're not dealing with someone who's participating in the giving and taking of reasons for things, and the way that most law-abiding people do, which most people are law-abiding, right?
I'd like to also make a quick word about judges. They, with the exception of the 9 members of the Supreme Court of Canada, every judge in this country has a boss or has someone who can overrule them. So they too are carefully managing the case to avoid the possibility of appeal, or in the event of an appeal, to avoid doing something that will lead to an overturning of the decision. So what this means in a practical sense is that quite often, especially when you have self-represented or unrepresented defendants, they are probably going to not assist them in a fulsome way, but they are going to give them the benefit of any ambiguity, of any question that might come up, like this issue of prosecutorial authority. A judge, if they hear that, they're probably not going to let that question go without making sure that there's a definitive answer, because that's something that will easily be overturned on appeal. And
then on the other hand, the sort of like help that they give the self-represented person won't be given to you at all.
Right.
And in fact, they'll take a position that's not only just not helpful, but one that's almost defensive.
Yes. Yeah. Zach and I have both had cases where the judge raised legal issues that the defendant never considered, and they will probably do that for you too, even if you are a lay prosecutor. They're not going to give you a different standard, because the risk in their mind is that they'll make a bad decision, which will see a punitive consequence go out that gets overturned, which looks bad, as opposed to a punitive decision doesn't follow through, which is less likely to be appealed and probably less likely to be the subject of derision.
Yeah.
How are we doing for time there, Sam?
11:48 there right now.
All right.
48.
I think it'd be a good opportunity just to open it up to some questions. If anyone has something outstanding, I'd love to chat on a topic or just
on anything. It doesn't even have to be necessarily related to the trial process.
Yeah. If you got a file that's cooking up and you want
free legal advice right now,
for the next 10 minutes.
I do have one sort of a clarification question coming back earlier to your elements of the offense. So as it is, we have to prove all the elements of the offense, but the defense only has to disprove one of them to win. Doesn't really seem fair.
Well, I appreciate it doesn't seem fair, but it's also it's worse than that. Not only do you have to prove all of the elements of the offense, the defense doesn't have to do anything. Up until the point that you do prove all of those offenses, all of the elements, then the defendant can elect to bring evidence that that contradicts those your evidence, but that's also at their own discretion. So really, they can just sit back and see if you've done your duty. So it is. I mean, I do appreciate it is unfair. I mean, it is designed that way to avoid wrongful convictions, which is a legitimate concern.
I've got another one here, just asking to clarify the difference where the 6-month limitation or 18-month limitation Jordan rule apply.
Oh, yes. Okay. Well, there's a bit of there's a distinction that has to be made there. The 6-month limitation is the default limitation under the Offence Act, and that's for bringing the prosecution or for laying the information. That has to be done. The MTI has to be issued in this context within 6 months of the offense. And I think that's within 6 months of the occurrence of the offense, yes, regardless of whether it's been discovered.
Yeah.
So there's a sort of a background obligation on enforcement to make sure that you're actively investigating things. Because
yeah,
if something slips under the radar,
yeah,
that's too bad. The 18-month limitation is from a Supreme Court of Canada case called R.V. Jordan. Do you want to talk a bit about that?
I mean, all I can release, I haven't had to deal with Jordan as much as you, actually, so I think you're in the better position. But I would just say that, yeah, it had to do with the charter right. The charter right is that you have a right to be tried within a reasonable time. The court basically put what essentially was a hard deadline on trying summary conviction prosecutions, which was 8 months. That's not to say that you can't win if you're over the 18-month period, but it becomes that your case, if it's from the beginning of laying the charge until the end of trial is beyond 18 months, it's presumptively unreasonable, meaning presumptively an unreasonable amount of time in which to try a matter. So that won't include delays that were caused by the other side. That won't be in the calculation, but I mean, if you delay for whatever reason and getting the disclosure out, not canvassing possible trial dates with the other side, so that you have to do a second appearance or something like that. Let's say you go to a first appearance and it gets adjourned on nobody's fault, and you go to a second appearance and that doesn't get scheduled for like 3 months later. Even though the adjournment of that is nobody's fault, it ends up being accounted to your time rather than to the defendant's time, unless the defendant is showing up and saying, I'm unprepared, and it's unreasonable for them to be unprepared. All of the time and delay is going to be attributed to you. And so it's a matter, the purpose is to keep these prosecutions happening at a pace that's fair to the defendant. We don't want to live in a society where people are in a Kafkaesque universe where, their prosecution is pending. They never know the results of their prosecution for years on end, right? And that's the purpose of it. I don't know if there's anything else you'd say about Jordan.
No, I mean, that's basically it. So you should be aware of 2 limits then. You have 6 months to lay the charge, and then you have 18 months from the day you lay the charge to complete the prosecution. That doesn't include the time it takes for the judge to make their decision.
Yeah, that's true.
So once trial has concluded and all the evidence is in, that's the clock stops running then. But it does include, as Zach said, even the only time that isn't counted against you is time where explicitly the defendant is responsible for the delay. So they weren't available, they had conflicting, whatever, it doesn't matter. As long as they're the one who's kicking the can, that be counted against them. But everything else, including like things that are just, wildly beyond anybody's control.
I mean, if the courts are just busy, if there are not enough judges, and so your matter, you can't get a trial date for 10 months,
right?
That's attributed to you because you're part of the justice system, right? It's about keeping the justice system in check. But so even though you have no control, obviously, over judge availability,
Right.
that affects you, which is all just to say that you need to do things as speedily as possible, as expeditiously as possible.
Yeah, the part that is in your control, making the disclosure, getting ready for the trial, making sure there's no delays on your part, that part you have to be very vigilant about. Because 18 months in a court,
Flies, yeah, it's crazy. Yeah.
Yeah,
Seems long, but it's not.
it's not. Oh, I guess just a piece of off-the-cuff advice about that. If you, and for MTIs, you shouldn't be in this position anyway, but if you are scheduling dates, always try to get the shortest date you think is manageable. So if it's 1 day of trial or less, go with that, because the longer you need to prosecute a matter, the harder it's going to be to get dates within time. And once you start getting into 2-3 dates, you're talking about months upon months.
Yeah, that's really good advice. Another thing I would do, just as a practical matter, you should be, doing what offices and lawyers do, is have a calendar that has a bring forward, and you've got to make sure that as soon as you you lay a charge, that you're putting in your calendar when the Jordan date is going to occur, and then even have earlier follow-ups on that. So it's like 6 months until Jordan triggers, 8 months until Jordan triggers, something like that, right? So it's in your head. Otherwise, it's very easy to forget, and might catch you by surprise at the end of the trial.
Mhm.
One more question here from Rob Harris.
Mhm.
Just asking, at what stage is the alleged offender provided disclosure? First appearance or even prior to that?
I would say if you want to be efficient about it and avoid the kind of delays we're talking about, really when as soon as an individual disputes the MTI, I would issue disclosure at that point. Or begin the disclosure process. Because if they go to the first appearance to set the date, let's say, it's too easy for them to say, I haven't gotten disclosure. And the court is, probably just going to shoot from the hip and be like, okay, well, we'll reschedule this.
Yeah, for sure. I think the judge will even ask, again, on one of those things where even if the defendant doesn't say anything,
Right.
I think the judge will say before you sit down, because you're going to have to estimate a time for trial, right? And you can't really realistically do that without knowing what the evidence is against you, right? And you guys are, you and the defendant are supposed to be setting a time that is agreeable to both parties, as much as you can do that. So a judge is going to ask right before that, has disclosure happened yet? And if it hasn't, it's the easy way for them to just punt the matter. They're busy, right? The judges, they have long hearing lists, and if there's some reason they can make a quick decision on your matter and have it shuffled off to somewhere else, they'll do it.
Oh, and I think actually that reminds me, a quick word about disclosure. As a practical matter, I would make sure when you are producing and serving disclosure on the defendant to make a record of that and even create an affidavit of that kind of service. Because I personally have been jammed up in a trial where a defendant claimed that they had never received disclosure, even though it had been given to them. And the judge, they're gonna largely side with the defendant on these kind of things.
They're always lenient.
Yeah.
And that especially because they're going to show up at a hearing, let's say the first appearance, or maybe even later at the beginning of trial or something like that, and they're not giving evidence to that, even though it is evidence. They can just say that procedurally, and you don't have a right to cross-examine them on that. So it's very easy for people to just lie and say, I never got this. That's not part of the case, and you don't get a chance to sort of question or make an argument, tell the judge why you for sure sent it. I mean, you can get up and say, yeah, we definitely sent it, but so long as the other side has some sort of explanation as to I didn't get it, they might even have not even have an explanation. They just get up and say, I never received it, even though you sent it to an email or something like that. The judge being lenient to defendants procedurally, because they don't, like Spencer said, they're always thinking about being reviewed by a higher court, are going to give it to them. And again, that just makes your fight against the Jordan timeline all the more difficult.
That clock is ticking all the time. Just like our clock is ticking to the end of this forum. I really appreciate you guys taking the time and hanging out and asking questions. We're going to keep doing these. I think the third installment is coming down the pipe. We will be in touch with information about Prosecute This, the next iteration. And yeah, great to spend some time with you, and look forward to serving you in the future.